Tommy V in Michigan. He was on fire this morning.
Okay, thank you, Tommy V in Michigan. Yes, sir. If you share my prayers.
Tommy V's on. Yeah, we'll jump over there.
Tommy V doing great stuff over there.
Good morning, sir. Please state your name.
Xavier Pierre Vaughn.
All right, Mr. Vaughn. Calling case number 24-219697. This is the people of the City of Auburn Hills versus Mr. Vaughn. Sir, you've identified yourself. Counsel, please put your appearance on the record. How'd you like to proceed?
Morning, Your Honor. Andrew Moxie for the defense. Waive any formal reading. Client stands mute. Kindly plead not guilty at this time.
All right, I'll enter a plea of not guilty for purposes of arraignment. Does your client wish to have a court-appointed attorney going forward? Does he qualify?
Yes, Judge. He's not currently working.
All right, I'll assign counsel in this matter. I'll enter a not guilty plea for purposes of arraignment and invite Mr. Vaughn is presumed innocent until proven guilty beyond a reasonable doubt. He's got the right to try the matter by judge or jury. He's got the right to remain silent. That silence cannot be used against him. He's got the right to be represented by an attorney. If he cannot afford one, the court will appoint one. The court intends to do so in this matter. It looks like the judge did set a bond, a bench warrant, because he failed to appear on this. My inclination is to continue that, but I'll listen to whatever argument you may have, counsel.
Judge, he resides by himself in Pontiac. He's looking for work. Doesn't seem to have an extensive history. I'd ask you to consider a 10% provision added to any bond you may set.
Okay. As Mr. Vaughn didn't appear for his court date, the court did issue a bond with a bench warrant. The court is inclined to continue that. So it'll be $500 cash surety, no 10%, with the conditions on Mr. Vaughn that he appear for any court proceeding, not leave the state without permission of the court, notify the court in writing of any change of address or telephone number, not possess firearms, other dangerous weapons, refrain from using any alcohol, not prescribe marijuana or legal drugs, no new criminal offenses, and he'll be supervised by the Rochester Court's bond compliance program. He'll be given their contact information before he is released. All right, you're all set, Mr. Vaughn. Thank you very much.
Thank you.
All right. Good morning, sir. Please state your name.
Zachary McCord.
All right. Calling case number 24-17139, people of the state of Michigan versus Mr. McCord. You've identified yourself for the record. Counsel, please put your appearance on the record. I'd like to proceed.
Morning, Your Honor. Andrew Moxie for the defense. Waive any formal reading of the information. Client stands mute. Ask the court to kindly enter a plea of not guilty at this time.
All right, the court will do so. Does Mr. McCord intend to request for court-appointed attorney? Is he going to retain counsel?
He's going to need appointed, and I believe he qualifies.
All right, thank you. In that event, I think assignment of counsel is appropriate. Mr. McCord, you do have an enter not guilty plea for purposes of arraignment on your behalf. You're presumed innocent until proven guilty beyond a reasonable doubt. You got the right to a preliminary examination within 21 days where the prosecutor must establish that this crime was committed and there's probable cause to believe you committed it. You've got the right to try the matter by judge or jury. You've got the right to remain silent. That silence cannot be used against you. You've got the right to be represented by an attorney. If you cannot afford an attorney, the court will appoint one for you, and the court intends to do so in this matter. Mr. Moxie, in light of Mr. McCord's lack of criminal history, but taking into consideration the seriousness of the offense, the court is inclined to set low to moderate cash bond with a 10% provision with standard conditions, but I'll listen to your argument.
I think that's appropriate. He has stable housing, resides with his stepmom and her boyfriend. He'll appear at court.
All right, I'll enter a bond in this matter in the amount of $7,500, cash surety, or 10%, with the conditions that Mr. McCord must appear for any court proceeding, not leave the state without permission of the court. He must notify the court in writing of any change of address or telephone number, not possess firearms, other dangerous weapons, refrain from using any alcohol, non-prescribed marijuana, or illegal drugs. No new criminal offenses. Will be supervised by pretrial services, who he must contact within 24 hours of his release. They'll be given their contact information. No contract with children under 17 years of age, and he must not be using social media. His next court date is a probable cause conference set for June 6th at 1:30 p.m. His exam is set for June 13th at 9 a.m. Both of those at the Pontiac District Court. All right, Mr. McCord, if you understand all that, you're all set. Push on the door. Deputy will be by to help.
All right. Quick question.
Sure.
Am I staying in jail?
Well, your bond is $750. It's $7,500, 10%. So the deputies will help try to arrange that for you once you talk to them.
Okay. Thank you.
Okay. Good luck. Good morning, sir. Please state your name.
Yes, sir. My name is Damaris Anthony Gray II.
Oh, Damaris Anthony Gray II?
Yes, sir.
Okay. Calling case number 21-3117, people of the City of Auburn Hills versus Damaris Gray II. Mr. Gray has identified himself. Counsel, please put your appearance on the record. How'd you like to proceed?
Andrew Moxie for the defense. Waive formal reading, judge. Client stands mute. If there's any outstanding bench warrants, I'd ask they be set aside at this time.
All right. Yeah, it looks like in this matter, a bench warrant was issued because defendant failed to appear back in 2021 for an arraignment pretrial. At that time, the judge set a bench warrant in the amount of $2,500, no 10%. My inclination is to continue that. First off, I'll enter not guilty plea for purposes of arraignment. I'll advise that you're presumed innocent until proven guilty beyond a reasonable doubt. You got the right to try the matter by judge or jury. You got the right to remain silent. That silence cannot be used against you. You got the right to be represented by an attorney if you cannot afford one. The court will appoint one for you, and the court intends to do so in this matter. I'm sorry, Mr. Moxie, did Mr. Gray, is he requesting a court-appointed counsel?
Yes, Judge, I believe he does qualify.
All right, so as I stated, we'll be assigning an attorney for you. With respect to bond, as I also stated, my inclination is to continue the bond that was set by Judge Asadorian, but I'll listen to your argument.
Judge, I understand, and I normally would agree to you, but with your recommendation from the judge, but Mr. Gray swears that he paid this ticket. He says he has proof or receipt at home. I'm hoping maybe you might go a little bit lower than what Judge Asadorian made. Occasionally mistakes do occur in court, but he's confident he paid this ticket.
Yeah, the issue is he didn't appear, so because he didn't appear, the judge issued a warrant for his arrest. So to ensure his appearance, I'm going to continue the bond that was set by the judge. It'll be $2,500 cash surety, no 10%, with the condition that Mr. Gray appear for any court proceeding, not leave the state without permission of the court, notify the court in writing. If any change of address or telephone number, not possess firearms or dangerous weapons, refrain from using any alcohol, non-prescribed marijuana, or illegal drugs, no new criminal offenses, and he'll be supervised by the Rochester Courts Bond Compliance Program. They'll be given their contact information before he's released. All right, Mr. Gray, if you understand that, you're all set. Push on the door. Deputy will be by to help. Hello, sir. Please state your name.
Dylan George.
All right, Mr. George. Calling case number 24-989, people of the state of Michigan versus Dylan George. You've identified yourself. Counsel, please put your appearance on the record. How'd you like to proceed?
Morning, Your Honor. Andrew Moxie for the defense. Waive any formal reading. Client stands mute. Kindly enter a plea of not guilty at this time.
I'll enter a not guilty plea for purposes of arraignment. I'll advise Mr. George he's presumed innocent until proven guilty beyond a reasonable doubt. He has the right to a preliminary examination within 21 days where the prosecutor must establish that this crime was committed and there's probable cause to believe he committed it. He's got the right to try the matter by judge or jury. He's got the right to remain silent. That silence cannot be used against him. He's got the right to be represented by an attorney if he cannot afford one. The court will appoint one on his behalf. Mr. Moxie, does Mr. George wish to have an attorney going forward, court appointed?
Yes, and I believe he qualifies.
All right, in that event, I think assignment of counsel is appropriate. My inclination is to set a low cash bond with a 10% provision, just to ensure defendant's appearance. But I'll listen to your argument, Mr. Moxie.
A low bond with 10% is fair, Judge, but he does reside with his grandmother up there in Highland. He's employed. He's a landscaper. This is a nonviolent matter. He fully intends to appear at court and deal with this. Perhaps you would go as low as a personal bond. Mr. George assures me he's going to attend his court hearings.
Yeah, I understand the argument, counsel. However, Mr. George does have a history of failing to appear, so the court's somewhat concerned about that. So I think some sort of nominal cash bond would be appropriate just to assure his appearance. Maybe if Mr. George appears as directed in district court, the judge may modify that and make it personal. That's up to the district court judge. But for purposes of this weekend, I'm going to set bond in the amount of $5,000 cash surety or 10% with the condition that Mr. George appear for any court proceeding, not leave the state without permission of the court, immediately notify the court in writing of any change of address or telephone number, not possess firearms or other dangerous weapons, refrain from using any alcohol, non-prescribed marijuana, or non-prescribed medications. He'll test once a week randomly for alcohol and drugs through pretrial services. We'll be supervising him. He'll be given their contact information before he's released, and he has to contact them within 24 hours and not commit any criminal offenses. His next court date is a probable cause conference set for June 3rd at 9 a.m. His exam is set for June 10th at 9 a.m., both of those at the Clarkson District Court, and he'll be given paperwork regarding that. Do you understand all that, Mr. George?
Yes, Your Honor. So my bond is $500, right?
Correct, sir. Yep.
Okay.
All right, good luck to you. Push on the door and the deputy will be by to help.
Okay. So I'm good to go?
Yes, sir.
Okay.
Good morning, sir. Please state your name.
Montel Devontae Bennett. And good morning to y'all too.
Hello. Let's see. Oh, I got your file right here, Mr. Bennett. All right, calling case number 24-548, people of the state of Michigan versus Mr. Bennett. Mr. Bennett, you've identified yourself. Counsel, please put your appearance on the record. How would you like to proceed?
Andrew Moxie for the defense. Waive formal reading. Is mute. Kindly enter a plea of not guilty at this time.
All right, I will enter a plea of not guilty for purposes of arraignment. I will advise Mr. Bennett that he's presumed innocent until proven guilty beyond a reasonable doubt. He's got the right to try the matter by judge or jury. He's got the right to a preliminary examination within 21 days where the prosecutor must establish that this crime was committed and there's probable cause to believe he committed it. He's got the right to remain silent. That silence cannot be used against him. He's got the right to be represented by an attorney if he cannot afford one. The court will appoint one for him. Do you understand all that, Mr. Bennett?
Yes, sir.
Mr. Moxie, does Mr. Bennett wish to have a court-appointed attorney, or is he going to retain counsel?
He'll need court-appointed judge, and I think he qualifies.
All right. I will assign court-appointed counsel in this matter. Although it is a 14-year felony, Mr. Bennett's history is not all that bad. It's a nonviolent offense. My inclination is to set a kind of a nominal cash bond on this with standard conditions, but I'll listen to whatever argument is.
That's pretty fair, Judge. I just want you to take into account he turned himself in, which is definitely a positive. He's got a solid residence with his girlfriend there in Southgate. And he recently got employed at Hercules Steel, so he's trying to do some positive things. It's kind of rare that someone will turn themselves in. So I would ask the court to take that into consideration.
All right, the court's going to set bond in the amount of $2,500, 10%. So your bond will be $250. And that's just to ensure that you do appear and protect the public. The conditions are you're not to return to the Pine Knob Wine Shop. You must appear for any court proceeding, not leave the state without permission of the court. Notify the court in writing of any change of address or telephone number. not possess firearms, other dangerous weapons, refrain from using any alcohol, not prescribed marijuana or legal drugs, no new criminal offenses, and you must contact pretrial services within 24 hours of your release. You'll be given their contact information. Do you understand all that, Mr. Bennett?
Yes, Your Honor.
All right, you're all set. If you push on the door, deputy will be by to help.
Okay, thank you, and I appreciate y'all so much, and y'all have a good day.
Thanks. Have a good day.
You too, thank you.
Good morning, sir. Please state your name.
Jaden Khalil Thomas.
All right. Calling case number 24-782. This is the people of the state of Michigan versus Thomason. You've identified yourself for the record. Counsel, please put your appearance on the record. How would you like to proceed?
Andrew Moxley for the defense, waive any formal reading. Client stands mute. Kindly enter a plea of not guilty at this time.
All right, I'll enter not guilty plea for purposes of arraignment. I'll advise Mr. Thompson that he is presumed innocent until proven guilty beyond a reasonable doubt. He's got the right to preliminary examination within 21 days, where the prosecutor must establish that these crimes were committed. There's probable cause to believe he committed them. He's got the right to try the matter by judge or jury. He's got the right to remain silent. That silence cannot be used against him. He's got the right to be represented by an attorney if he cannot afford one court appointment for him. Mr. Moxley, does Mr. Thomason desire to have a court-appointed attorney going forward?
Yes, and I believe he does qualify.
All right, then I'll assign counsel. With respect to bond in this, we're going to have the standard conditions where he cannot harass or threaten any witness. He must appear for any court proceeding, not leave a state without permission of the court, notify the court of any change of address, not possess firearms, and he'll be supervised by pretrial services. However, counsel, my inclination is to deny bond in this matter, as one of these cases is a capital offense, but I'll listen to your argument.
Judge, I would just ask that you set some type of cash bond rather than a denial outright at this time.
Okay. So the court, in light of the fact that the seriousness of the offense, that one of these matters is a capital offense punishable by maximum life in prison, at this point, I'm going to deny bond. The district court judge can revisit that and decide to give you a bond if that's what they determine is appropriate. Your probable cause conference is set for June 3rd at 9 a.m. Your exam is set for June 10th at 9 a.m. Both of those at the Clarkson District Court. All right, you're all set, Mr. Thomason. Good morning, sir. Please state your name.
Larry Fletcher.
All right. Calling case number 23-2418, people of State of Michigan versus Larry Fletcher. So you've identified yourself. Counsel, please put your appearance on the record. I'd like to proceed.
Morning, Your Honor. Andrew Moxley for the defense. Waive formal reading. Client stands mute. If there's any bench warrants, I'd ask they be set aside at this time.
All right. Does your client desire to have a court-appointed attorney going forward?
He does, and I believe he qualifies.
All right. In that event, I think assignment of counsel is appropriate. This is just a straight bench warrant where Mr. Fletcher was already arraigned on this, but failed to appear for a pretrial, and the judge set a bond in the amount of $5,000 cash surety. My inclination is to continue that, but I'll listen to your argument.
Judge, I would just ask you consider attaching a 10% provision to that bond.
Okay. I think this bond is set by the judge as appropriate, so I'm going to continue that. Also, it'll be $5,000 cash surety without previous conditions to continue. You'll be notified of your next court date, Mr. Fletcher. So you're all set. If you push on the door, deputy will be by to help.
Okay. Thank you. Have a good one.
Good luck. Good morning, sir. Please state your name.
White Edward Chappelle Jr.
All righty. Calling case number 24-1713402. This is the people of the state of Michigan versus Dwight Edward Chappelle Jr. You've identified yourself for the record. Counsel, please put your appearance on the record. How would you like to proceed?
Morning, Your Honor. Andrew Moxley for the defense. Waive formal reading. My client will stand mute. I'd ask the court kindly enter a plea of not guilty at this time.
I'll enter a not guilty plea for purposes of arraignment. I'm going to advise Mr. Chappelle that he's presumed innocent until proven guilty beyond a reasonable doubt. He's got the right to a preliminary examination within 21 days where the prosecutor must establish that these crimes were committed and there's probable cause that Mr. Chappelle committed them. He's got the right to remain silent. That silence cannot be used against him. He's got the right to try these matters by judge or jury. He's got the right to be represented by an attorney. If he cannot afford one, the court will appoint one for him. Mr. Moxie, does Mr. Chappelle wish to have a court-appointed attorney going forward?
Yes, and I believe he qualifies.
All right, in that event, I believe it's appropriate to assign counsel in this matter. And then we do have a number of charges here, and viewing that and in light of the background of Mr. Chappelle, the court does have some concerns, but I'll listen to an argument with respect to bond. Mr. Moxie.
Judge, Mr. Chappelle does have a solid residence. He has a job also as a custodian at a local church. Sounds like he does have a defense here with a co-defendant. He definitely will be appearing at court to try to argue his position. So I'd ask the court to consider going on the lower end of a cash bond with a 10% provision.
Yeah, counsel, you are correct in that even though Mr. Chappelle does have a bit of a history, to his credit, he's not on a release status right now. He doesn't have any pending warrants, and he has no history of failing to appear in court. So I'll take him at his word that he'll appear as directed. I'm going to set bond in the amount of $10,000 cash surety or 10%. So that'll be $1,000 with the condition that Mr. Chappelle not have any contact with Clifton Lewis, that he appear for any court proceeding, not leave the state without permission of the court, that he notify the court in writing of any change of address or telephone number, not possess firearms, other dangerous weapons, refrain from using any alcohol, not prescribed marijuana, or illegal drugs. He'll test one time a week randomly for alcohol and drugs through pretrial services. We'll monitor him. He'll be given their contact information prior to release, and he must contact them within 24 hours. His probable cause conference is set for June 6th at 1:30 p.m. His exam is set for June 13th at 9 a.m. Both of those at the Pontiac District Court. All right, Mr. Chappelle, if you understand all that, you're all set. Push on the door. A deputy will be by to help. Good morning, sir. Are you Mr. Devonair Lee Calhoun?
Yes.
All right, calling two cases. One is case 231459, which is the people of the city of Auburn Hills versus Mr. Calhoun. That matter is in bench warrant status. And then we've got 24-171135, which is the state of Michigan versus Mr. Calhoun. That matter is up for an arraignment this morning. Mr. Moxie, please put your appearance on the record. I'd like to proceed.
Andrew Moxie for the defense. Waive formal reading. Client stands mute. I'd ask not guilty plea be entered and any outstanding bench warrants be set aside at this time.
All right, I'll enter a not guilty plea for purposes of arraignment with respect to the 2024 case. In respect to the 2023 cases, indicated that that matter is in bench warrant status. Judge Asadorian set bond at $750, no 10%. My inclination is to continue that, but with respect to the 2024 case, just presume innocent until proven guilty beyond a reasonable doubt, has a right to a preliminary examination within 21 days where the prosecutor must establish that these crimes were committed. There's probable cause that Mr. Calhoun committed them. He's got the right to try these matters by judge or jury. He's got the right to remain silent. That silence cannot be used against him. He's got the right to be represented by an attorney in both these files. If he cannot afford an attorney, the court will appoint one for him. Mr. Moxie, does Mr. Calhoun wish to have a court-appointed attorney going forward?
Yes, and I believe he qualifies.
All right. Then I'll assign counsel in both these matters. With respect to bond in the 2024 and 2023 cases, Mr. Moxie, what do you have to say?
Judge, he's got a solid residence there in Southfield, lives with his sister and his young children. He's employed in a landscaping, mostly tree removal service. They cut up and take down the damaged trees or fallen trees. I don't see any assaultive incidents here. He didn't resist the police. I think that's certainly to his credit. I'd ask you, you go with a very nominal cash bond on this new matter.
All right, I do appreciate the argument on this, Mr. Moxie. With respect to 2023 file, the court's going to continue the bond. That'll be $750, no 10% without previous conditions to continue. With respect to the 2024 file, the court does have some concerns as opposed to the gentleman we just arraigned a few minutes ago. Mr. Calhoun does have a number of holds and a number of warrants and a history of failing to appear in court as ordered. So the court does have some concerns there. So to ensure Mr. Calhoun's appearance and to protect the public, the court's going to set bond in the amount of $75,000 cash surety or 10%, with the condition that Mr. Calhoun appear for any court proceeding, not leave the state without permission of the court, notify the court in writing of any change of address or telephone number, not possess firearms, other dangerous weapons, not use any alcohol, marijuana, or illegal drugs, the new criminal offenses and pretrial services supervision, with his next court date being June 4th at 1:30 p.m., which will be his probable cause conference, and his exam set for June 11th at 9 a.m., both those at the Pontiac District Court. So, Mr. Calhoun, if you understand all that, you're all set. If you push on the door, deputy will be by to help.
What'd you say my bond was again, sir?
On the one case, it's $750, no 10%. On the other case, it's $75,000, 10%.
Okay.
All right, you're all set. Thank you.